Yeah, I mean, fundamentally, the standard in the U.S. to obtain a patent, and it's some form of that is similarly found outside the U.S. is that what you have created is novel, it's new, and non-obvious, meaning it's not an obvious improvement over what was already known in whatever that field is, and so. That's something that's tested by patent examiners when you apply for a patent, but certainly part of the job of a lawyer advising someone on patent strategy is to kind of give them some, be able to look around the corner, give them some heads up of whether it appears what you've innovated it indeed is something you uniquely came up with, or something that it turns out others have done or others have done a very minor variation on, and therefore you wouldn't be entitled to a patent.
How long does that process take?
Well, to obtain a patent, I mean, it can take, on average, it's 2 to 3 years to go through the patent office. There are ways to accelerate that. But, particularly because when you're looking at software-based technology, which so much of technology is right now, yeah, that would be a reasonable expectation.
And what would an average cost be?
So that can vary. So and I'm certainly not. So it's not actually the work that our firm does. We advise people in terms of strategy of patent. We don't actually file patent applications for people. So I can't give you a price point, only to say you could be looking at anything in the order of $10,000 to $15,000, depending on the complexity of the application.
I'm wondering specifically for companies, say they're trying to come up with some kind of innovation or something. Just curious. What that would be? Yeah,
I mean, I think I think that's the advice people give most folks. If it's a young company, they're looking to whether they should be patenting in their technology. To sit down and spend some time with a patent attorney, understanding whether it is in fact patentable, and then to move through that process, and basically a lawyer assisting you with the process at the patent office. There's a back and forth that goes on when the patent examiners look at the technology and say, we found something else that looks really close. Don't think what you did was new. So there, yeah. But then you understand better what the invention is, and there may be a way to articulate to them that in fact what we did was new because it's different in these ways. But there's a back and forth in that, and that's what takes time, and that's what takes the 2 to 3 years. And because the job of the patent office is to search far and wide, and make sure that someone else hasn't already done it. The job of your patent lawyer is to help you understand how to articulate your invention in a way so that they understand what you did that was different. And so that can be fairly involved, but that, I think, for many young companies understand that is one way to demonstrate to potential investors that what they've developed is in fact distinct enough to have long-term value. So
I actually don't know. Do you? How does that work for, say, a startup in acquiring investors, but like maybe they don't have a patent yet, but investors want a patent, but you can't really get a patent unless you're like getting going. Can you speak on that at all? I don't know if that's a little outside of.
No, what your question is, how do people deal with that?
Like, I guess, where in the process should someone who's coming up with a new kind of innovation start the patent process?
Oh, I see. Yeah, sure. I think if you think what you've done is highly innovative and you're not aware of others who are doing it, you should think about whether to obtain a patent. Now, there's a cost-benefit analysis, right? There's going to be, first of all, you need to find out if it's patent eligible. There are some things, for example, in software, and financial services in particular was impacted by this, in that if you're merely trying to capture with a patent something, say automating a well-known business method, and you're using basic function of the computer, you're not making some improvement on the technology itself, that's not patent eligible. And if you think you've done something more than that, you need to figure out how to articulate that in a way that shows you've made a technological improvement.
Figuring out how to use existing technologies differently rather than actually inventing something.
Yeah, well, take a perfect example. I think, some examples are there's case law that shows that or articulated the fact that, say, the idea of learning how to or being able to use some sort of form of hedging to modify your investment. Well, the idea of hedging in trading was something that's well known and done for years and years and years and years. The fact that you figure out how to use a computer just to do that well known method would not be patentable. That's essentially the set of decisions called Alice, the Alice decision and the Bilski decisions that basically said these basic, well-known economic and financial methods, if all you've done is use a general purpose, the well-known functions of a computer to implement that wouldn't be patentable. But move to something like, for example, blockchain, where, what you may be doing is, at the end of the day, related to financial services and may in fact enhance something like trading. But what you're doing is fundamentally modifying the way the computer operates, either by being able to leverage the ability to actually to do some mining and generate cryptocurrency, or being able to create the networks that will allow you to communicate and transfer money via the blockchain, whatever or transfer value, we'll say. Whatever you're doing there, you may be able to articulate in a way that show you've made a fundamental change in the technology, the underlying technology, rather than just use an existing computer function. So taking a step back to your question about, well, how soon should somebody try to make that evaluation? You probably want to make that evaluation very early on, because I think it sets up some of the protections you're going to put in place. One of the things that the Patent Office won't let you do is if you've already disclosed widely to the public more than a year before, or you put on sale more than a year before you went to the Patent Office with your idea, then that basically created what they've considered prior art to your patent. You've disclosed to the world, and it's now known to the world, and the world has a right to use it if you didn't go fast enough to the Patent Office to gain what ultimately would be exclusive rights by getting the patent. So not everything will be patentable, but to have the conversation and consider it,
So there's a time limit.
There's a time limit if you've made it publicly known. I mean, to extent, and back to it informs your decisions. If you're keeping it secret in your organization, then you're fine. But once you're starting to, or if you're talking to investors and it's under a non-disclosure agreement, so that's fine. You can do that, and people do that, right? That's how it's the only way often people are able to get investors involved. But you want to be mindful of, is my tech team going out there with a white paper, or is my tech team going out there and talking to people to try to, or my marketing team, if we have
clock starting.
The clock is ticking. Exactly.
Gotcha.
Exactly.
Speaking of blockchain, I know that you can file patents in different countries, right?
Sure.
So how does that work when it comes to enforcement, especially when it comes to, I imagine this being really relevant when we're talking about decentralized and democratized applications built on, say, the blockchain technology. So how does that work when you're trying to enforce a patent?
We're going to find out.
I have no idea.
So no, I'm going to give you a more
you let me know when you find out.
Yeah. So challenging. So okay, kind of several layers there, but so your patent is obtained in a particular jurisdiction. So you've got a U.S. patent, you've got a patent. There's such a thing as a European patent for the not all, but a substantial amount of Europe. Or you can get a patent in individual countries, right? So there's a particular jurisdiction where you would have rights to enforce that patent. Something like blockchain that could be highly decentralized may make it difficult for you to first detect where infringement is happening, so that you could try to enforce your patent. May make it difficult for you to identify where the harm is, so that you would, even if you could detect infringement, identify a harm such that you're entitled to damages. So there will be challenges with that. That said, a lot of the use cases that you see right now are essentially private blockchains. They're not really running on the public blockchain. And those private blockchains have an entity that controls them. And that entity sits somewhere and is subject to the jurisdiction of at least one place where you may have a patent. I see.
Because so that makes it much easier because it's contained.
In that sense,
it is
contained.
Centralized.
It is centralized, right? The public blockchain is more challenging, but then you probably look at, well, what's the use case, right? You're not your suit is not against the blockchain itself; it's against some particular application or some particular modification someone made, and that someone probably sits within the jurisdiction. Finding them could be challenging, sure, depending on what we're talking about.
How does it work? Again, kind of putting technology aside, just speaking patents generally. A patent that was filed and, say, accepted in one jurisdiction, but then is, say, used or infringed upon in another country. Does that apply or no?
Maybe, and by this I mean, so the enforceability of the rights is defined by the jurisdiction. So a U.S. patent is only enforceable with respect to an infringement that occurs within the United States. That said, there may be an entity, and this happens all the time. There may be an entity outside the U.S. that is doing some activity that's resulting in infringement here in the U.S. Well, you can sue them here in the U.S. I mean, foreign companies are sued in the U.S. all the time for patent infringement. That certainly could happen. I think, is that answering your question?
Yeah. I mean, I guess I'm just thinking that maybe this is bringing the technology back into it. I'm thinking if, say, there's some specific, I'm throwing this out of nowhere, someone creates some kind of, I would say flying cars, even though I know there's still kind of flying cars out there. Someone patents a flying car here in the U.S., but then someone else creates one in Europe with the same technology or whatnot.
Okay.
How would
so
that
that's
work?
exactly why people look to get patents in multiple jurisdictions, because that's a great example. I created here in the U.S. I got a U.S. patent only, and that's where my business is. And I figured I didn't need to worry about the rest of the world. But turns out, over in Germany, someone did the exact same flying car. You're out of luck if you don't have rights that are enforceable in Europe in some way, either through a European patent or through a patent. Well, there's kind of different levels. It's what's called a utility model in Germany and patents as well. If you don't have one of those enforceable rights that would apply in Germany, you may be out of luck if the only place that car shows up
Right.
is and the only place they're flying in, the only place that any activity related to that is in Germany, then you may be out of luck.
Do you think patenting hurts or helps innovation?
Well, there's that. It's a good question. I don't think you could ask an IP lawyer.
I gotcha.
I think it's hard for me to tell you that patents don't help innovation. I think, but here's probably the better response. That would be the knee-jerk response.
Well, I can see both sides, actually, to be honest.
Well,
I really can.
And that's really it. I think there is a barrier to entry that comes along with patenting that may, for some people, be discouraging innovation, and that is unfortunate. But is patenting a way, because it provides exclusive rights, of giving someone a chance to recruit their investment in innovation? Absolutely, and that's the value in it.
I've heard this in regards to drug development. Because it costs so much.
Right?
Yeah.
Well, that's the easy case, right? Because of the long horizon for research. And there are plenty of people say, well, software innovation moves so fast. The investment cycle is not that long. You can recoup your investment pretty quickly, sometimes quicker than you'll get your patent is issued. How on earth? Right? No, it's a fact.
That's so true.
Right? So I mean, if you put together an app and have it launched within a year's time, you could actually beat
well,
your
the patent's pending for years after.
And my response to that is that's true at one level. I think if you look long term if you're thinking about something where you're trying to build out a market, and even though your initial initial version of whatever it is you have maybe launched before you had a patent, I think it's hard to make a case for any substantial technology platform that doesn't evolve over time, and that you wouldn't want to protect your core innovation as you start to move broader and broader out. So you think about something like any of the technologies used by Google for searching, for Facebook. If someone stopped and said, well, you know what, we got the search engine up, it's good, we don't need a patent, we're fine. And you're right. You had something that had some value the day you launched it. That's true. But it will continue to have value. That value will only increase over time. To be able to protect that investment in the long run, I think, and which is why you see folks like Google and Facebook patenting heavily. I think they patent heavily, right? Because I think that, at that scale, you understand that protecting your investment is important. Is there still some room for saying we over patent in some ways? Sure. I think there's valid arguments for that.
Yeah, because that's very true when it does come to technology and software. I mean, that's, of course, this is a simplified statement, but you could essentially just take the code and copy the code, and then you have say the Google search engine. You have the Google algorithm.
So different issues. So intellectual property is more than just patents, right? It's copyrights, and so you that software, once it's instantiated, is already protected by copyright. Now you need to register it, and if you intend to enforce that copyright against someone, but so you have some protection whether you decide to pursue a patent or not. It's a question of the scope of it, and if you really want to enforce an infringement case, whether you've taken the steps you need to do that.
Yeah. Well, I mean, let's jump into that because I talked with Marta about this a little bit, but I would love to hear your perspective on why, let's say, blockchain technology and intellectual property are merging.
Well, not just yet, but I think, I think some of the ways that could potentially merge, and one of the ways, in fact, we've assisting some clients is being able to take, for example, a license agreement for a particular software software module and record that on the blockchain. That sort of application already exists, right? That sort of platform does exist. You could imagine where you expand that to actually being able to use the blockchain to essentially be a smart contract that executes the license. Mm-hmm. So rather than really being a way of recording the license, it's self-executing in some way so that you're implementing on the blockchain. That's protection of IP. That's a little different than saying it's a substitute for the rights that, frankly, the government provides us by having copyright and having trademarks and having patents. Those are different, very different things. And I think ways of managing IP rights, absolutely, the blockchain will be useful for. But the two things are not interchangeable. Does that make sense?
Yeah, sure. Yeah. And in order for that to happen, certain softwares and technologies are going to have to be built on top of the blockchain in order to make that happen. Is that right? Or in kind of a broader question being, because of the underlying, blockchain foundation, which, by the way, to the audience members, like I'll just say, with your colleague Marta Belcher, her and I, we had almost an entire episode talking about blockchain. So yes. If anyone wants to dive deeper into that, I highly encourage them to go check out that episode. But for here, since we're diving deep in, I know that everyone's kind of jumping on top of this blockchain technology. They're building, innovations. There's a whole boom happening right now. What does that mean in this conversation of like patenting? What does that mean? Can you patent a innovation built on top of an open source platform?
Yeah, no, that's a great question. So I think that the answer is depends. It depends, as most lawyerly answers are. And so there's a couple of things going on there. So back to, I mentioned before, the difference between the public and the private blockchain. A private blockchain could, because it has basically created some of the core technology needed to define, first of all, what it will define the protocols for how you determine and validate whether it's a valid transaction on your particular blockchain. We would have to have designed it if you made a private blockchain. You will have to design what it means to mine and generate a new and create a new block on that chain. Defining all of those things, that's fundamental technology that for the most part should be patentable, unless of course you're doing it in a way someone's already done before. There are by now multiple such private blockchains, right?
So you can patent your own version of a blockchain.
Certain elements of it, certainly. So the challenge is, and back to your question about the open source. So the public blockchain, couple of things that make it challenging to patent. One is, open source, and so much already has been disclosed about how that fundamentally technology is defined, right? Many of the fundamental protocols, whether it's how you generate a block, how you validate a block, all those fundamental steps that would be necessary to build any use case on top of a blockchain, at least in a version, and the version being for Bitcoin, that use case, Bitcoin is a use case, right, of the blockchain, that has been defined and that's dedicated to the public, right? That's the Nakamoto paper. Those white papers make that all known to the public. And then to the extent that people have created open source based blockchain platforms and dedicated that to the public, you can't now claim that as your own and patent it. So there are challenges with that. That said, every use case, or particularly if you create a private blockchain and you're adding layers to the technology that are unique in your own, could potentially be patentable. Sure.
Okay.
Sure.
I know that, or wait, is it true that you also, well, I guess that's another, I was going to say, I heard that you also can't patent blockchain because it's considered a concept. Is there anything to that?
I'm not sure what's meant by that.
Yeah.
I mean, because, yeah, it's hard to, I'm not sure how to respond to that. And what's giving me pause is so at the end of the day, to patent something, you have to demonstrate that you have command of the conception and reduce to practice is the standard that we use. Means that you can describe to someone in enough detail how to implement that, such that it shows that you actually had possession of the invention. And so you didn't actually have to implement it in a way that was a prototype even.
Like,
you've just described it in enough and robust enough detail that it's clear that you had it. So in that sense, it's an idea, it's a concept. It's not necessarily a particular implementation or instantiation. So to say that you couldn't patent blockchain for that, or blockchain use cases or blockchain technology for that reason wouldn't be accurate. You cannot patent the concept of a blockchain. Of course not. First of all, it exists. Secondly, that doesn't say anything. You've got to get down to what specifically, because wow, it's fairly complex. But if you think about what blockchain is, it is the ability to use a hashing and encryption of some form of data to first of all create a unique block, and then be able to add something on that's generated using those, we'll say the same, but some form of encryption or hashing that can be used to validate that the block I created
that connects them together.
Not just connects them together, but says the basis for which I created that first block is the same basis for which I created the next block, and then I bring those together into that's the chain, right? The blockchain, and then when you add on to that and you want to add on another, I can only do that if first I understand how they created those first two, and they validate that when I created this new one, that it goes on. And that's back to the consistent and being decentralized. That's why you can have those nodes anywhere, because every time you're adding to the chain, everyone is already there. It's like, well, you can't add to this chain unless you can show us, you can prove to us that you've generated the chain according to the method that we've set forth. So going back to the question of, well, you can't patent blockchain because of concept. That fundamental concept, which is already disclosed in Nakamoto's paper, no, of course you can't patent that. But all the different ways you might implement that and all the ways you might enhance technology to do that faster and more securely, oh yes. If you've come up with a novel way of doing it that is not obvious in view of what's already out there, you could potentially patent.
Now let's say,
people have. I mean, I don't know if I can't recall now if Marta talked about the sheer number of patents there are right now.
So there's a lot already.
There's a lot already.
Do you know how many?
It's people. They're mixed measures, but it's easily in the thousands.
Oh wow.
Yeah.
Pending or like actually granted?
Granted.
Wow.
Yeah.
Do you know how many pending?
I don't.
Probably a lot more than that.
Yeah, a lot more than that. And people will debate whether something should be in versus out in terms of what you consider a blockchain patent. But yeah,
Let's say whoever Satoshi Nakamoto was public from the beginning. Could they have patented Bitcoin and the blockchain technology?
If they had been public,
instead of being anonymous this whole time and secretive.
Oh, sure. Yeah. I mean, could they have decided instead of dedicating it to the public the way they did? Oh, sure. Yeah. Well, they should have been able to. Now, whether, depending on which patent office you appeared at and how well you described and explained it, but given the level of detail that's described in those white papers and what we know that technology, hard to imagine they couldn't have.
How do you think Bitcoin would be different today if that had happened?
Great question. Don't think it would be where it is today as fast. I do think there is and this is the reason people do open source, right? To get adoption. But that doesn't mean I think there are people who say you kind of fall on one side or the other. It's either it's open source or it's patent, and it's like no. Actually, you can do both. I mean, Android's a perfect example. There's a certain level you can dedicate to the public in order to gain adoption, but there's other things that provide very unique services on top of it that you may choose to patent that because they are valuable and unique, and your innovation that you have a right to reclaim some value from.
Is this what people call like patent pledges?
Patent pledges are a little different. So patent pledges are kind of, if you have the worldview that even if I get a patent, I won't enforce it, or I want to limit the ways I can enforce it, then that's what patent pledge is about. There's an agreement among, it may be unilateral agreement, and the way that the Twitter innovation pledge does, which is say that you just make a unilateral statement as to how I will limit enforcing my patents, or you can do it among a group and form some sort of network that makes a pledge or an arrangement. A pledge may be an overstatement, but some sort of arrangement with respect to how they may limit their patent rights.
So in the kind of the hypothetical case of Bitcoin, could maybe not an official patent pledge, but essentially what you're saying is could they have patented Bitcoin and blockchain, but still kept it open source for everyone? So,
interesting question. So yeah,
essentially with no limitations.
Yeah, they certainly could have, right? And said I'm gonna patent it for reasons that, to basically
just so no one else can claim it or something. I don't know. Yeah.
Right. And then say, but yet I'm never going to enforce those patents. In fact, there are open source agreements where that, open source licenses rather, where that is in fact the restriction. I believe it's a GPL. The federal GPL license is an example where you have to make you have to make certain obligations, or you have under certain obligations to either distribute or make available your source code, things that would be, they don't directly speak to patenting, but would be at odds with later deciding I'm going to get a patent, or at least enforce my patents on the technology. So yeah, they might have done that. I suspect.
But he didn't, so it's too late.
Well, so back to our earlier discussion about patenting in every jurisdiction. So if we believe what you're told, that it was in Australia, and even
is that what they say?
You hear some talk, right? I don't know. Nobody knows. There was some
I heard
guy
it was in Santa Monica.
Yeah, well, that's just it. Depending on who you talk to, who knows where, who he or they are. But it could have been, like I point out, it could have been a jurisdiction where even having a patent there maybe wouldn't have given you rights to worldwide, and wouldn't at the end really limited your ability to control adoption. But that's it. It's an interesting question. Yeah. I like it.
What has the reaction been from the open source community? Have they generally been in favor of patenting, not in favor?
Ooh, yeah, mostly not.
Yeah.
I think. And it's hard to characterize broadly the open source community as a monolith, right? Because there's right now, and I say that because there are companies who make large amounts of their software available through open source and very dedicated to it, but they also patent, right? They patent other aspects of their technology. So, but by and large, most people who are fully dedicated to the notion of software being available as open source think patents are at odds with that. Mm-hmm. I don't agree, but I understand it.
What about patent wars? Because of these big technology booms, Marta touched on it a little bit about people trying to jump on it.
It may be, in that sense, history repeats itself. I think we've seen that. I don't know that means we'll always see it, and I say that for this reason. So because people have gotten to a different place of how they navigate patents with each other, and the proliferation of technology means that so many different types of companies have patents, are managing their assets that way, and their solution may not be, or their first approach may not be litigation, whereas maybe in the past that was very often for someone like me who does litigate IP cases, like, wow, that's a shame because I think these cases are interesting.
Yeah.
That said, I think it's also very interesting and very encouraging to see the very intelligent ways companies have come together, even across industries, and figure out ways. I mean, these are you mentioned the patent pledges, but other forms of defensive, loosely what we call defensive patent licensing, these strategies for figuring out a way to ensure that I can protect my technology from some, competitor next door grabbing it and grabbing all the value from it. But I also, if you're willing to work with me, there's no reason we need to engage in a war and try to tear each other down. There may be a way that this market, and obviously, well, maybe not obviously, but there are antitrust limitations to how much you can do that and how much any one industry can do that. But when you're looking at something like blockchain or something like AI, where there's many industries involved, and it's harder to make an argument for there's an antitrust issue because you're not necessarily controlling any one market. Does it make sense for players to come together across industries and think of smart ways to limit their potential liability with respect to patents? Sure. And so maybe we don't get to wars in quite the scale that we did in the past. That remains to be seen.
Have you seen any like real life cases of I've heard that this maybe is or is becoming a problem of bigger companies kind of taking advantage of smaller startup companies because when it comes to patents, because they have the means to outlast them in patent litigation?
So always hard for me to see these things from the standpoint of patents being misused. No, because I fundamentally believe in the fact that patents protect value. That said, is it fundamentally true that a small entity will not have the resources to litigate a patent case in the way large? Of course. But there are many things that have been implemented, some with varying degrees of success, to try to address that. There have been entities that acquire patents at large scale from small inventors with the idea of giving them some value for their innovation and taking on the risk of being able to enforce it, being able to recapture all of the value. I think that puts some limits on how much a small entity finds itself in a unfair fight in that sense. I think the other thing that you see is that large companies are often some of the investors in these small entities. And so super, super, super important that those relationships are not adversarial in many cases, right? And so it's hopefully the rare case where that's where you have to end up, where you've got a small entity fighting a very large one. It usually makes more sense to come to a business deal in that case, but not always, and occasionally you do see that.
Speaking specifically with FinTech, if a lot of these larger companies, which in the financial world generally are financial institutions like banks or whatnot, if they are able to get a lot of control over these innovations, what do you think that means for the original intent of like a decentralized decentralized transactional world and trying to lean off the reliance of banks?
Yeah, so I think it's a bit of a utopian view, I think.
Is it?
Or some people would say anarchy, of the view that you would be able to completely remove some form of some central trust. Let's put aside whether it's the banks we know or even a central bank, that you ultimately don't have maybe central trusts, but at least a substantial number of trust agencies that allow you to say, even for Bitcoin, right? I mean, you look at the wild fluctuations in value and the ways in which it had to be forked, right? And then the fight now over what is the more valid fork or what's more valuable. that the world wouldn't seek an arbiter or arbiters to help with those kind of disputes is hard to imagine. Now, who that is it a technologist? Is it a bank? Is it a government? I think that is all could be all up for grabs, but it's hard to imagine there wouldn't be some such, for lack of a better term, oversight. Does that make sense?
Yeah. This is kind of off topic, but I heard this and I thought it was actually really interesting regarding a way that your blockchain could be used with patents. I heard that in theory, if someone merely checking to see if an invention was patented and recording that search on a blockchain, that they could then use that search as proof that they knew about this invention or had an idea for this invention to then be eligible to patent it if it wasn't already patented by another entity. Have you heard of that before?
I haven't heard of that. Interesting. The short answer is maybe, and with everything depends. So there could be a way of using a blockchain to record the fact that you had substantial enough knowledge about whatever that innovation was, and having that recorded somewhere such that you could not, someone else couldn't later come and say that they had the same invention. The difficulty with that, and this maybe gets to our AI discussion, is how do you determine that they're the same, right? The thing that works about, well, there are many things, but one thing that works about the blockchain is it can be agnostic to the content of what's recorded by any particular block. It's the fact that you've recorded it and encrypted it in a way that I can be validated that it's a block that belongs on my blockchain, but it doesn't actually have to have any intelligence about the contents of it, right? Bitcoin, it turns out its value, but you can use the blockchain for something other than monetary value, right? So if your idea is to use the blockchain to validate that I created a particular invention, let's just say even you disclose it at the level of detail that's required in a patent, which is pretty substantial, right? Several pages at least, if not more.
It was a really detailed search.
Pretty detailed, right? So let's just say you take the simplest of those, and there's some simpler versions of, I mentioned the German utility model. You can make a less fulsome disclosure, but even if you have some disclosure to capture what your invention is, how do I determine without, it's probably a human, but some really sophisticated AI, that what someone later came along and said was mine is what you put on the blockchain originally? What the blockchain could do is record the fact of it and fix it in time, and maybe that's valuable. But you can do that. People do that all the time. Nakamoto did it. You just publish a white paper. You can do that in any number of ways. I'm not sure. Maybe I don't understand the concept completely, but I'm not sure how the blockchain.
I guess having the validity of it, because if it's in a blockchain, then it's a fact that it happened then.
Sure, and no dispute over, who it was who.
I mean, I guess you're right. Technically, you could email yourself that, and that's also a timestamp.
Yeah. So there's, or like I said, if you're meaning to dedicate it to the public, put it out on the white paper. That's. So there's other ways to do that, but there may be more to that concept. But just the mere kind of assertion of priority of your invention, there's probably easier ways to do it.
That's one. I mean, I guess you could if you really wanted to.
Yeah.
Hey everyone, thanks so much for watching the episode. If you're interested in contributing to the conversation and supporting the show, there's 2 easy things you can do. 1, click subscribe, and 2, visit our Patreon page where you get exclusive access to the Exploring Minds community.